Family law attorneys should anticipate and plan for the impact that divorce will have on their clients' Social Security benefits, a key source of retirement income for most people. Although more retirement options are available to married couples, important choices are also available to single and divorced individuals. For a client to get the most from Social Security, the attorney needs to know what retirement, survivor, and disability options are applicable to them, and then develop a benefit strategy before alimony and property settlement negotiations ensue in earnest. What do you say when a divorce client asks, "How much will I get in Social Security? When is the earliest I can begin receiving benefits? What happens if I remarry?" And the kicker, you're a smart lawyer, shouldn't you know this? The right answer is both yes and no. While it matters in divorce negotiations, Social Security benefit strategies are more in the nature of financial advisory services. Nevertheless, all lawyers should have a basic understanding of what's what. A quick disclaimer before getting started. This discussion is intended to be a general overview of the state of Social Security benefits in retirement as of September 2023, and exceptions may apply. Dancing around federal benefits. In Tennessee divorce law, Social Security benefits are very much an enigma. From one perspective, Tennessee courts have no authority to divide or impair Social Security benefits. The benefits are what they are. From another perspective, these benefits are terribly important for alimony analysis. The eligibility for retirement benefits and their payout both increase the supporting spouse's ability to pay and reduce the supported spouse's need. Benefits are often substantial. Negotiating alimony and property division from a position of strength requires a benefit strategy that encompasses Social Security, a non-negotiable federal program. Spouses may include settlement terms in their marital dissolution agreement to optimize those federal benefits. Yet there is nothing spouses might agree to, attorneys might draft, or a judge might order that can alter either spouse's individual right to Social Security benefits. This makes planning for the client's future benefit alternatives absolutely crucial. Social Security benefits for a divorced spouse and current spouse. Whether for a divorced or a current spouse, Social Security benefits are a key component of retirement. What is the benefit at full retirement age? Will the earnings cap result in forfeited benefits? How much will annual cost of living adjustments help? As a marital strategy, spouses coordinate their benefit claims. As a divorce strategy, an economically dependent spouse should seek support and property resources that complement benefits for a comfortable post-divorce lifestyle. The supporting spouse is better off with a strategy that builds on the supported spouse's optimized benefit. It is the duty of the counsel representing the supporting spouse to assist the client in negotiating favorable divorce terms that recognize both spouses' need to optimize benefits and ease the financial burden of support obligations and marital asset and debt division. Spouses negotiate and mediate alimony, equitable distribution of marital property, and parenting plan issues. The divorce attorney is in a position to guide the client toward a settlement that considers both parties' Social Security benefits. Before negotiating financial issues for the parties' marital dissolution agreement, it is crucial to obtain and review the client's official schedule of benefits from the Social Security Administration. Social Security planning for aging spouses. We have been warned for 2 decades about the phenomenal number of baby boomers heading into retirement. Boomers are now retiring at a rate of about 10,000 per day, and many are divorced or will be. Social Security benefits make up half or more of most people's retirement income at age 65 and older. Clearly, clients who are Gen Xers, millennials, and same-sex spouses also require strategies for optimizing benefits. Various divorce strategies build on Social Security retirement, survivor, disability, and children's benefits. For general retirement planning, get information directly from the Social Security Administration website at ssa.gov. Utilize their online Social Security Quick Calculator. Certain rules and exceptions apply to public employees, and important exceptions may apply to the client's particular situation. Family lawyers don't know everything about Social Security benefits, so be willing to refer technical retirement benefits questions to a Social Security benefits lawyer, financial advisor, or tax attorney, especially if related to income taxes. For additional reference, Mary Beth Franklin, contributing editor of Investment News, has an ebook on the topic, Maximizing Social Security Retirement Benefits. Links for all of these resources are in the description below. Benefits are based on other spouse's work record. A benefit strategy should strive to obtain the maximum allowable benefit after divorce for when it's finally time for the client to retire. Full retirement age depends upon your client's birth year and will not be later than age 67. A worker may also delay retirement to age 70, the maximum age for delayed credits. Explain to your client that his or her decision to optimize personal benefits takes nothing away from the former spouse's benefit or from his or her current spouse if remarried. To develop a fact-based strategy, each divorcing spouse should obtain his or her own Social Security statement from SSA.gov. The official report is the only way to know with certainty what benefits will be paid based upon each spouse's own work record. Fortunately or unfortunately, the same rules apply, even if it's not the first divorce for your client or the other spouse. Benefits are collected on an individual's own work record and on the work record of one former spouse. There is no stacking marriages or combining work records to increase benefit amounts. That's a myth and is not permitted. What percentage of Social Security benefits can be reserved for divorced spouses? Say that you represent the economically dependent spouse. Assuming the client qualifies, to determine how much his or her benefit will be as a divorced spouse, the Social Security Administration compares the client's work record with the other spouse's work record. Your client will receive the larger amount. The maximum spousal benefit is 50% of the former spouse's retirement benefit at full retirement age. This is critical for the stay-at-home parent or the spouse who managed the family business but never drew a salary. Statistically, in divorce, women suffer economically more than do men. Look for ways in which those financial negatives may be turned around. Divorcing spouses of both sexes need to make decisions based on knowledge, not guesswork. Recommend that your clients consult with financial advisors and planners about personal retirement planning. Have a local referral list ready too. It's that important. How much Social Security does an ex-spouse get? Qualifying for Social Security benefits generally requires accumulating 40 credits in lifetime earnings, which are earned through one's work record. If the client does not qualify on his or her own work record, or it's insufficient, then the client may qualify on the former spouse's work record. A few rules determine the client's right to collect on a former spouse's benefit, which include: the client must have been married at least 10 years to that former spouse. Is the marriage hovering at 9.5 years? Hold off filing for divorce. Divorce proceedings already pending? Delay them. The divorce decree must be entered after 10 years of marriage, not a day sooner. The client must be at least 62, the earliest retirement age. The client must be unmarried. Benefits accrued under the prior marriage are revoked by remarriage, but are unaffected by the former spouse's remarriage. If the client's new marriage ends in death, divorce, or annulment, then the right to an earlier former spouse's benefit revives. The client's work record must provide less benefit than what the client would collect based on the former spouse's work record. The former spouse must qualify for Social Security before the client begins collecting on that benefit. Is the former spouse still not collecting benefits? If both parties are at least 62 years of age and have been divorced at least 2 years, then the client can start collecting on the former spouse's benefit. How much an ex-spouse gets depends upon his or her full retirement age, which is determined by their year of birth. Earliest retirement age. The individual decides when to retire, not the SSA. However, age 62 is the earliest anyone can start collecting retirement benefits. By claiming early retirement benefits, any time before the client's full retirement age, the amount is forever reduced. Collect early, collect less for life. To gain a better understanding, take a look at this table provided by the Social Security Administration. For our illustration, we have used a $1,000 primary insurance amount. With this primary insurance amount and supporting spouse retiring at their respective full retirement age, the supporting spouse would receive $1,000 per month, and his or her ex-spouse would receive up to $500 per month. The table shows that retirement at age 62, a full 3 to 5 years before their full retirement age, will reduce in substantial reductions in monthly benefits. Life expectancy matters. How is the client's health? Does longevity run in the family? What kind of work can the client do? Will the marital dissolution agreement provide sufficient resources to spend down if retirement is postponed until age 70? At age 70, the retirement benefit maxes out on one's own record. A tailored alimony schedule and well-crafted property settlement could make postponing retirement feasible. For instance, a 65-year-old may implement a divorce strategy wherein alimony is the primary source of support until age 70. Perhaps larger alimony and futuro payments for the first 5 years, with a substantial reduction in alimony or termination, coincident with collecting benefits at age 70. Be aware, too, that about 40% of claimants must pay income taxes on their benefits. Another reason for the client to consult with a financial advisor and crunch the numbers. Later retirement. Collect later, collect more for life. By waiting until age 70 to claim the benefit on one's own work record, the age at which Social Security maxes out, boomers born before 1960 enjoy maximum delayed retirement credits of 32%. However, waiting until age 70 will not increase the spousal benefit. Those whose full retirement age is 66 enjoy an 8% per year delayed retirement credit, a significant plus. For those whose full retirement age is 67, maximum delayed retirement credits at age 70 drop to 24%. In either case, develop a strategy that allows the client to collect the most, simply by delaying retirement to age 70. Importantly, the maximum spousal benefit is 50% of the other spouse's primary insurance amount benefit at full retirement age. However, that does not include delayed retirement credit amounts. To learn more, the Social Security Administration website provides a calculator to measure benefits for spouses. Link in the description below. Earnings after retirement. An individual can claim Social Security benefits and continue working for a price. If the client is earning wages at their full retirement age, there is no reduction in benefit amount. The earnings cap is lifted. Early retirement triggers the earnings cap. Countable earnings are wages and salaries, or self-employed net earnings. Fortunately, there is no limit on income from investments, pensions, rents, government benefits, and the like. How does the earnings cap apply? If the client retires early at age 62 and has employment income, then the benefit amount will be reduced by what he or she earns above the earnings limit. The Social Security Administration says, quote, "In the year you reach full retirement age, we deduct $1 in benefits for every $3 you earn above a different limit. But we only count earnings before the month you reach your full retirement age. If you will reach full retirement age in 2023, the limit on your earnings for the months before full retirement age is $56,520. End quote. The Social Security Administration withholds monthly benefit payments until the earnings cap is satisfied. Months could pass with no benefit payment at all. Furthermore, excess benefits received from SSA must be repaid. A professional whose salary is well above the earnings cap may find early retirement a bad strategy, but there are exceptions. In the months just preceding full retirement age, the SSA allows greater wages to be earned without forfeit. If you are under full retirement age for the entire year, we deduct $1 from your benefit payments for every $2 you earn above the annual limit. For 2023, that limit is $21,240. Impress upon your client the importance of determining exactly what the earnings cap will be before that early retirement date closes in. What happens to early retirement benefits not paid because wages exceeded the earnings cap? At full retirement age, the Social Security Administration recalculates the benefit and gives credit for those months in which no benefit was paid due to the earnings limit. Determine the benefit amount with various earnings and retirement dates. Calculate benefits. Then head into settlement negotiations. For more detail, visit What Happens If I Work and Get Social Security Retirement Benefits. Be sure to visit ssa.gov for current year earnings limits as well. Links for these resources are provided in the description below. Age-related options and other things divorce lawyers need to know. Some older individuals have options not available to their younger counterparts. Divorce attorneys must identify the rare client who qualifies for one or two Social Security claiming strategies, receiving more later by collecting less initially. These benefit strategies were closed to most retirees by the Bipartisan Budget Act of 2015. Benefit strategy number 1, File and Suspend option. The File and Suspend option allowed a qualifying individual to file for benefits at full retirement age, and then immediately suspend benefits to keep working. But why did this make economic sense? Upon claiming, the dependent spouse and minor child became eligible for auxiliary benefits. The qualifying spouse could continue working to age 70, accruing 8% per year in delayed retirement credits. A lump sum payment for suspended benefits was an available option. The strategy for a married couple was a coordinated effort to receive less now and more later. Only those who claimed benefits at full retirement age before the April 30, 2016 deadline by selecting the File and Suspend option were grandfathered in. Between married spouses under prior law, only one could file and suspend, and one could file a restricted claim for spousal benefits, which we will discuss next. If they were divorced and both 62 years old or older on January 1, 2016, then at full retirement age, each could file a restricted claim for spousal benefits on the other's work record. This allowed one's own benefit to continue growing until age 70. What if your client is not grandfathered in? A limited file and suspend claim at full retirement age is still available to qualifying individuals. Under current law, delayed retirement credits can accrue until age 70, but during suspension, no benefits can be collected by anyone. Benefit strategy number 2, restricted claim for spousal benefits option. The restricted claim for spousal benefits option is another benefit optimization strategy, but it is for a dwindling number of divorcing spouses. By restricting a claim to spousal benefits, the individual claims the former spouse's benefit at full retirement age while continuing to work, thereby increasing his or her own benefit until it tops out at age 70. It's the best of both worlds. Option eligibility. Who is eligible? This option is available only to those born on or before January 1, 1954. If born after that date, whether married or divorced, an individual is deemed able to file for both spousal and retirement benefits. The Social Security Administration compares records and pays the higher amount. The result is different with survivor benefits. Ex-spouse Social Security benefits after death. Another consideration for divorcing spouses is the Social Security survivor benefit for widows, widowers, and divorced former spouses. Survivor benefits are still available to those born on and after January 1, 1954. A surviving divorced spouse chooses which benefit to collect first, his or her own benefit or the survivor's benefit on the deceased former spouse. By collecting the survivor's benefit first, one's own retirement may be postponed in order to accumulate delayed retirement credits until age 70. Alternatively, the divorced spouse could start with his or her own benefit and switch to the survivor benefit at full retirement age. To collect the survivor benefit on a former spouse, the client must be at least 60 years old, or 50 if disabled, and they must have been married to each other for 10 years. This chart shows the percentage the survivor receives on the deceased former spouse's benefit. If the decedent postponed benefits until age 70, the survivor collects 100% of the former spouse's benefit, with delayed retirement credits included. To take a look at the chart with more detail, see full retirement age for survivors born between 1945 and 1956. Link in the description below. What if the client remarried after the former spouse died? Timing matters. If remarried before turning 60 or 50 if disabled, the survivor benefit is unavailable. As a strategy, maybe the client should wait to remarry. When the client is raising the deceased parent's child, the child may also receive benefits on the decedent's work record. The child must be under age 18 or under age 19 if still a full-time high school student. The primary residential parent could receive a benefit if the child is still under age 16. An older disabled child may also receive benefits on the deceased parent's work record. What if the other spouse dies during divorce proceedings? Of course, the marriage terminates immediately with divorce proceedings dismissed. With regard to benefit collection, the marriage must have lasted 9 months for a widow or widower to collect the survivor benefit, and they must have been married 1 year for the survivor to collect the spousal benefit. One last thought. Start preparing a Social Security benefit strategy early in the divorce representation. For purposes of retirement planning, the client needs to know what alimony arrangement and division of marital assets and debts will allow for comfortable living when added to retirement, disability, or survivor benefits. Engaging a financial advisor in the process can help with optimizing the client's right to benefits. The longer the marriage and the closer to retirement the spouses are, the more pressing this concern becomes. Divorce cannot add to or subtract from either spouse's benefit, but a tailored marital dissolution agreement can build nicely on a benefit foundation. To learn more, visit memphisdivorce.com, Tennessee's most comprehensive free online family law legal resource. memphisdivorce.com answers hundreds of frequently asked questions on divorce, alimony, property division, custody, and more with videos, and hosts our Tennessee Family Law blog. Check out Miles Mason's author page on Amazon.com. He is the author of 3 books, including The Tennessee Divorce Client's Handbook, now available on audiobook and Kindle. Discover all you can learn with Miles Mason Family Law.